I was sitting on my back porch with a cold beer in hand when I saw the most ridiculous thing I had ever witnessed in my 37 years of life. 3 members of the Lakeside Estates Homeowners Association were standing on my private dock, measuring it with a tape measure, while one of them hammered a sign into my property that read, "Community Dock, No Private Use." I nearly choked on my drink. My name is Adam Brennan, and I had lived in this lakefront community in Coeur d'Alene, Idaho for 5 years. I had purchased my property specifically because it came with a private dock extending into Lake Coeur d'Alene. The dock had been built by the previous owner with all proper permits, and it was explicitly listed as part of my property in the deed. I paid a premium for waterfront access, and that dock was mine, not the community's. Mine. I set down my beer and marched across my lawn toward the dock. The woman leading the charge was Patricia Whitmore, the HOA president. She was a 50-something woman with short blonde hair, styled in that particular way that seemed to be a requirement for every HOA president across America. She wore white capri pants and a floral blouse, and she had that expression on her face, the one that said she was absolutely certain she was right about everything. "What the hell are you doing on my dock?" I called out as I approached. Patricia turned to face me with a tight smile that did not reach her eyes. "Good afternoon, Adam. We're simply claiming what belongs to the community. According to the covenants, all waterfront structures are community property." I stopped at the edge where the dock met the shore. "That's complete nonsense. This dock is on my property. I have the deed right inside my house that proves it." "Your deed may say that," Patricia said, adjusting her sunglasses on top of her head. "But the original covenants for Lakeside Estates clearly state that all docks, boat launches, and waterfront amenities are for community use. Your dock was built in violation of those covenants." The man with the hammer, Gerald Simmons, the HOA treasurer, nodded vigorously. "We've let this slide for too long. The previous owner should never have built a private dock. We're correcting that mistake now." The third person was Linda Chen, the HOA secretary, who was busy taking photographs of my dock with her phone. She did not even look at me, just kept snapping pictures from various angles. I felt my blood pressure rising. "Get off my property now, or I'm calling the police." Patricia's smile grew even more condescending. "This isn't your property, Adam. That's the whole point. And if you interfere with official HOA business, we'll have to fine you. $500 per day for obstruction." "You cannot fine me for telling you to get off my own dock." "We can and we will," Gerald said, finally setting down his hammer. "The board voted unanimously last week. All private docks are being reclaimed for community use. There are 47 homes in Lakeside Estates, but only 6 have waterfront access. That's not fair to everyone else who paid HOA dues." I could not believe what I was hearing. That's not how property rights work. You cannot just decide that my dock belongs to everyone because other people feel left out. I paid for this property. I own this dock. Patricia pulled out a manila folder from her large tote bag. "Here's a copy of the covenant, Section 12, Paragraph 4. It's very clear." She held out the papers, and I snatched them from her hand. I scanned the document quickly. It did appear to be a covenant document for Lakeside Estates, dated 1987, which was when the development was first established. And there, in Section 12, Paragraph 4, was language that said all waterfront structures, including docks, piers, and boat launches, were to be maintained as community property for the use of all residents. But something felt wrong. When I had purchased my home 5 years ago, I had reviewed all the covenants, restrictions, and HOA rules very carefully. I had never seen this language before. In fact, I specifically remembered asking about the dock during closing, and my real estate attorney had confirmed it was private property, not community property. "This doesn't make sense," I said, flipping through the pages. "I reviewed the covenants when I bought my house. This wasn't in there." "Perhaps you didn't read carefully enough," Patricia said with that infuriating smile. "Or perhaps your attorney was incompetent. Either way, this is the original covenant, and it's legally binding. I want to see the original document, not a copy, the actual recorded covenant at the county recorder's office." Patricia's smile faltered for just a moment. "The covenant is on file. You're welcome to look it up yourself. But it won't change anything. The board has made its decision. As of today, this dock is community property. We'll be installing a reservation system so residents can sign up for time slots. And what about the other 5 waterfront properties? Are you seizing their docks too? Gerald and Linda exchanged glances. Patricia cleared her throat. We're addressing each situation individually. Your dock was flagged as the most egregious violation because it's the largest and newest. That was interesting. My dock was not the largest. The Morrison family, 3 houses down, had a dock twice the size of mine, complete with a covered boat lift and a floating platform. But Thomas Morrison was on the HOA board as vice president. What a convenient coincidence. This is theft, I said flatly, and I'm going to fight it. You're welcome to appeal to the board, Patricia said, already turning away. We meet the first Tuesday of every month. You'll have 5 minutes to present your case. Until then, this dock is off limits to you for private use. You may sign up for time slots like everyone else. They left, walking back across my lawn toward the street where Patricia's white Lexus SUV was parked. I stood there holding the covenant copy, my mind racing. Something was very wrong here. I needed answers, and I needed them fast. I went back inside my house and immediately pulled out all the paperwork from when I purchased the property. The deed, the title insurance policy, the HOA documents I'd received at closing, everything. I spread it all out on my dining room table and started reading. My copy of the covenants was dated 1987, same as the one Patricia had given me. But when I got to section 12, paragraph 4, the language was completely different. My version said that waterfront property owners were responsible for maintaining their own docks and that dock construction required HOA architectural approval, but there was no mention of community ownership. None. I grabbed my phone and called my real estate attorney, Marcus Webb. It went to voicemail. I left a message explaining the situation and asking him to call me back as soon as possible. Then I called my title insurance company. After navigating through an automated system for 10 minutes, I finally reached a representative named Donna. I need to file a claim, I said. The HOA is claiming that my dock is community property based on a covenant that contradicts what was in my title report. Donna asked me a series of questions and told me she would open a claim file. Someone would contact me within 3 business days. 3 business days. In the meantime, the HOA was probably already printing up reservation cards for my dock. I decided to take matters into my own hands. I grabbed my keys and drove to the Kootenai County Administration Building in Coeur d'Alene. The recorder's office was on the 2nd floor. A helpful clerk named Janet assisted me in pulling up the recorded covenants for Lakeside Estates. These documents were recorded in 1987, Janet explained, clicking through the digital records on her computer. Let me print you a copy of the complete recorded covenant. I waited impatiently as the printer slowly produced page after page. When it finally finished, I grabbed the stack and immediately flipped to section 12. My heart was pounding as I read paragraph 4. The language matched my copy exactly. Waterfront property owners were responsible for maintaining their own docks. Dock construction required HOA architectural approval. There was absolutely no mention of community ownership or shared use. Can you tell me if this document has ever been amended? I asked Janet. She checked her computer. No amendments on file. This is the only recorded covenant for that development. I felt a surge of vindication mixed with rage. Patricia Whitmore had given me a forged document. The HOA president had literally fabricated a covenant to try to steal my property. This was not just an HOA being overzealous. This was fraud. This was criminal. I paid for the certified copy of the recorded covenant and drove straight to the Coeur d'Alene Police Department. I asked to speak with someone about filing a report for fraud and forgery. After a short wait, I was directed to Detective Russell Hayes, a middle-aged man with gray hair and a tired expression. I explained the entire situation, showing him both versions of the covenant document. Detective Hayes examined them carefully, comparing the sections side by side. So the HOA president gave you this version, he said, pointing to Patricia's copy, which states the dock is community property, but the actual recorded covenant at the county says no such thing. Exactly. She fabricated this document to try to seize my dock. That has to be illegal. Detective Hayes leaned back in his chair. It's definitely concerning, but HOA disputes are usually civil matters, not criminal. You'd need to prove that she intentionally forged this document with criminal intent. What else would you call it? She created a fake legal document and is using it to take my property. I understand your frustration, Mr. Brennan. Let me look into this. I'll need to keep copies of both documents. If we can establish that the document was forged and that Ms. Whitmore knew it was forged when she presented it to you, then we might have grounds for charges. But you should also contact an attorney and pursue this through civil court. I left the police station feeling somewhat deflated. I had hoped Detective Hayes would immediately march over to Patricia's house and arrest her, but I understood that the legal system moved slowly. I needed a lawyer, and I needed one who specialized in property law and HOA disputes. Back at home, I started researching attorneys. After several phone calls, I found one who came highly recommended for HOA cases. Her name was Rachel Norton, and her office was in downtown Coeur d'Alene. She could meet with me the following morning. That night, I barely slept. I kept thinking about Patricia and the board standing on my dock, hammering that sign into my property like they owned the place. The audacity of it was breathtaking. How long had they been planning this? Had they done this to other homeowners? And why was my dock specifically targeted? The next morning, I arrived at Rachel Norton's office at 9 o'clock sharp. She was a woman in her early 40s with dark hair pulled back in a professional bun. Her office was neat and organized, with law books lining the shelves and several framed degrees on the wall. I sat down and laid out both versions of the covenant on her desk. Then, I explained everything that had happened, from Patricia's invasion of my dock, to my visit to the county recorder's office, to my conversation with Detective Hayes. Rachel examined the documents with the practiced eye of someone who had seen every trick in the book. "This is one of the more blatant cases of HOA overreach I've encountered," she said, "and if they forged this document, they've crossed the line into criminal behavior. Can we stop them? They're claiming they'll find me if I use my own dock. We're going to do better than stop them. We're going to take them to court and make sure this never happens again. First, I'll file for an emergency temporary restraining order. We need to prevent the HOA from enforcing this fake covenant while we litigate the matter. Then we'll file a lawsuit for declaratory relief, asking the court to confirm that your dock is private property. We'll also pursue claims for fraud, civil conspiracy, and intentional infliction of emotional distress." How long will this take? The TRO hearing should happen within a few days. The lawsuit itself could take several months to a year, depending on how hard they fight. But based on what you've shown me, we have a very strong case. Rachel got to work immediately. Within 2 hours, she had prepared and filed the petition for a temporary restraining order. The hearing was scheduled for Friday, just 3 days away. In the meantime, she sent a cease and desist letter to the HOA, demanding that they remove the sign from my dock and stop representing that the dock was community property. I went home and waited. I did not go out on my dock, not because I believed the HOA had any authority to stop me, but because I did not want to give them any excuse to claim I was being confrontational or aggressive. I wanted to win this the right way, in court, with the law on my side. On Wednesday afternoon, I received a letter from the HOA. It was a formal notice of violation stating that I had been observed using the community dock for private purposes and that I was being fined $500. I had to pay within 10 days or face additional penalties. I immediately scanned the letter and emailed it to Rachel. She called me within minutes. "They're doubling down," she said. "This is actually good for us. Every action they take based on the forged covenant strengthens our case. Don't pay the fine. Don't respond to them. Let me handle everything." Friday morning arrived, and I met Rachel at the Kootenai County Courthouse. The hearing was in front of Judge Martin Campbell, a stern-looking man in his 60s. Patricia Whitmore was there with the HOA's attorney, a slick-looking guy named Brad Sullivan, who wore an expensive suit and had perfectly styled hair. Judge Campbell called the hearing to order. Rachel stood and presented our petition, explaining that the HOA was attempting to seize my private dock based on a fraudulent document. She presented both versions of the covenant and the certified copy from the county recorder's office. "Your Honor, this is a clear-cut case of forgery and fraud," Rachel argued. "The recorded covenant makes no mention of community ownership of docks. The HOA president fabricated a document and is using it to dispossess my client of his property. We're asking for a temporary restraining order to prevent any further enforcement of this fake covenant while we litigate the matter. Judge Campbell turned to Brad Sullivan. Counselor, I'd like to hear your response. Brad stood up smoothly. Your Honor, there seems to be some confusion about the documents. The HOA maintains that there were multiple versions of the covenant circulated during the development phase in 1987. While the version filed with the county may reflect one draft, the version that was distributed to the original homeowners and that has governed the community for nearly 40 years is the one that includes the community dock provision. I could not believe what I was hearing. He was actually arguing that the fake document was the real one and the recorded covenant was just a draft. Rachel was on her feet immediately. Your Honor, that's absurd. The covenant recorded with the county is the legally binding document. That's the entire purpose of recording deeds and covenants with the county recorder. It provides notice to all property owners and establishes a clear chain of title. You cannot simply claim that an unrecorded version supersedes the recorded version. Does the HOA have any evidence that the recorded covenant was merely a draft? Judge Campbell asked, looking at Brad. We're gathering historical documents, Your Honor. We believe we can show that the community has operated under the community dock provision for decades. Can you show me even one example of this provision being enforced before last week? Rachel interjected. One instance of any dock in Lakeside Estates being claimed as community property? One reservation system? One time slot sign-up sheet? Brad hesitated. The HOA has been lax in enforcement, but that doesn't mean the covenant isn't valid. Judge Campbell held up his hand. I've heard enough for today. Mr. Sullivan, I'm troubled by the discrepancy between these documents. The recorded covenant is very clear, and it contradicts the version your client is relying on. Unless you can provide compelling evidence that the recorded covenant is not the controlling document, I'm inclined to grant the temporary restraining order. Your Honor, we respectfully ask for time to gather evidence, Brad said. You have until the hearing on the preliminary injunction, which I'm scheduling for 2 weeks from today. In the meantime, I'm granting the TRO. The HOA is prohibited from enforcing the alleged community dock provision, from fining Mr. Brennan, and from interfering with his use of his dock. The sign that was posted on his property must be removed within 24 hours. If the HOA violates this order, they'll be held in contempt. I wanted to cheer, but I maintained my composure. Rachel had warned me that this was just the first step. We had won the TRO, but we still had to prevail at the preliminary injunction hearing and then at trial. As we left the courtroom, Patricia Whitmore glared at me with pure hatred. She pulled Brad Sullivan aside and spoke to him in a harsh whisper. I could not hear what she was saying, but I could tell she was furious. Outside the courthouse, Rachel and I discussed next steps. They're going to try to find evidence to support their position, she said. They'll talk to old-timers in the community, look for historical HOA records, anything that might suggest the docks were meant to be communal. We need to be prepared for that. What can I do? Talk to your neighbors. Find out if anyone else has seen or heard about this supposed community dock provision, and if you can find any of the original homeowners from 1987, talk to them. Get statements about what they were told when they bought their properties. I spent the next week canvassing my neighborhood. Most of my neighbors were shocked when I told them what the HOA was trying to do. Several of them had purchased their homes specifically because they did not have waterfront access and did not want the responsibility or expense of maintaining a dock. The idea that they now had shared ownership of my dock was news to them. I spoke with Donald Reeves, who had lived in Lakeside Estates since 1992. He was one of the earliest residents who was still around. I've never heard anything about community docks, Donald told me as we stood in his driveway. When I bought my place, there were already 3 or 4 private docks on the lake. Nobody ever said we could use them. They belonged to the people who owned that property. Would you be willing to sign a statement saying that? Absolutely. What Patricia is doing is wrong. She's been on a power trip ever since she became HOA president 2 years ago. First, it was the paint colors. Then it was the mailboxes. Now this. Someone needs to stop her. I collected statements from 6 different long-term residents, all of whom confirmed that there had never been any community docks and that private docks had always been understood to belong to the waterfront property owners. I also tracked down Margaret Fletcher, who had been one of the original homeowners in 1987. She had sold her home in 2003 but still lived in Coeur d'Alene. I drove to her assisted living facility and spoke with her in the common room. "Oh yes, I remember when Lakeside Estates was built," Margaret said. She was a tiny woman in her 80s with bright blue eyes. "My late husband and I bought one of the first homes. We were on the interior, not waterfront. We knew the waterfront lots were more expensive because they came with lake access and you could build a dock." "Did anyone ever tell you that you had the right to use other people's docks?" Margaret laughed. "Heavens, no. Those docks belonged to the people who paid for that property. It wouldn't have been right for us to just waltz onto someone else's dock. We had to use the public boat launch if we wanted to go out on the lake." "Would you be willing to testify to that in court?" "If it'll help stop this nonsense, absolutely. I still have friends in Lakeside Estates. They've been telling me about all the problems with the new HOA board. It's gotten out of control." By the time the preliminary injunction hearing arrived, Rachel had a thick binder full of evidence. We had the certified recorded covenant, statements from current and former residents, photographs of the private docks going back decades, and even old real estate listings that advertised the homes as having private dock access. The hearing was again in front of Judge Campbell. This time, the courtroom was more crowded. Several of my neighbors had shown up to support me. I also noticed some local reporters in the back row. Apparently, word had gotten out about the case, and the media was interested in this story of HOA overreach. Brad Sullivan started by presenting what he claimed was evidence of the community dock provision. He had old HOA meeting minutes that mentioned waterfront amenities and community lake access. He had photographs of HOA events held at the public beach area. He had testimony from Patricia Whitmore herself, who swore under oath that she had always understood the docks to be community property. But when Rachel cross-examined Patricia, things fell apart quickly. "Ms. Whitmore, you became HOA president 2 years ago, correct?" "Yes." "And in those 2 years, how many times has the HOA enforced this community dock provision?" "We only recently began enforcement." "That's not what I asked. Before you tried to seize Mr. Brennan's dock, how many times did the HOA treat any dock in Lakeside Estates as community property?" Patricia shifted in her seat. "We were planning to implement a comprehensive waterfront policy." "So the answer is 0 times. Not once in the 38 years since Lakeside Estates was established has any dock been treated as community property. Is that correct?" "We were not properly enforcing the covenants." Rachel pulled out a document. "This is an email you sent to the HOA board on April 3rd of this year. Can you read the highlighted portion for the court?" Patricia's face went pale. "I don't recall this specific email." "Let me refresh your memory. You wrote, 'We need to find a way to give all residents lake access. It's not fair that only 6 homes have docks. I'm researching whether we can amend the covenants to require dock sharing.' Does that sound familiar?" Patricia did not respond immediately. Brad Sullivan stood up. "Objection, Your Honor. I don't see the relevance." "The relevance," Rachel said sharply, "is that 2 months before Ms. Whitmore claimed my client's dock was community property, she was admitting in writing that it was not. She knew she needed to amend the covenants to create a dock sharing system, but then she decided to skip that process and simply forge a document instead." The courtroom erupted in murmurs. Judge Campbell banged his gavel. "Order. Ms. Norton, that's a serious accusation." "It's a serious crime, Your Honor, and I can prove it." Rachel presented a forensic analysis she had commissioned from a document examiner. The expert had examined Patricia's copy of the covenant and determined that Section 12, Paragraph 4, had been altered. The paper stock was consistent with the rest of the document, but the ink was different and the typography did not match. Someone had carefully cut out the original Paragraph 4 and replaced it with a new paragraph printed to look like the original. "Your Honor," Rachel said, "this is not a case of dueling interpretations or competing versions. This is fraud. Ms. Whitmore deliberately altered a legal document and presented it as authentic in order to steal my client's property. We're asking the court to grant a preliminary injunction, and we're also asking that this matter be referred to the prosecutor's office for criminal investigation." Judge Campbell looked at Brad Sullivan. "Counselor, do you have any response to this forensic evidence?" Brad looked like he wanted to disappear. "Your Honor, I was not aware of any alteration to the document. If Ms. Whitmore provided me with false information, I am as much a victim as Mr. Brennan." "Ms. Whitmore," Judge Campbell said, turning to Patricia, "did you alter this covenant document?" Patricia's mouth opened and closed several times. Finally, she spoke in a small voice. "I was trying to do what was best for the community." The courtroom went silent. She had just admitted it. In front of a judge with reporters present, the HOA president had confessed to forging a legal document. Judge Campbell's expression was thunderous. "This is one of the most egregious cases of abuse I've seen in my years on the bench. Not only am I granting the preliminary injunction, but I'm also referring this matter to the Kootenai County Prosecutor's Office for potential criminal charges. Ms. Whitmore, you are ordered to have no further contact with Mr. Brennan or his property. The HOA is prohibited from taking any action against Mr. Brennan based on the altered covenant. This court will also be notifying the Idaho State Bar about Mr. Sullivan's involvement in presenting a forged document to the court." Brad Sullivan jumped up. "Your Honor, I had no knowledge that the document was altered. I relied on my client's representations." "Then you should have done your due diligence, Counselor. This hearing is adjourned." As I walked out of the courtroom, I was swarmed by neighbors congratulating me and reporters asking for comments. Rachel handled the press, giving a brief statement about the importance of property rights and the dangers of unchecked HOA power. Over the next few weeks, the story exploded. Local news stations ran segments on the case. The Idaho Statesman published a front-page article titled, "HOA President Admits to Forging Documents to Seize Homeowners Dock." Social media was full of people sharing the story and expressing outrage at Patricia Whitmore and the Lakeside Estates HOA board. The Kootenai County Prosecutor's Office opened a criminal investigation. Detective Hayes, who I had originally spoken to, was assigned as the lead investigator. He obtained a warrant and seized all of the HOA's records, including emails, meeting minutes, and financial documents. What they found was even more shocking than I had imagined. Patricia had not acted alone. Gerald Simmons, the treasurer, and Linda Chen, the secretary, had both been involved in the scheme. Emails revealed that the three of them had discussed the plan for months. They knew that the recorded covenant did not support their position, so they had deliberately created a forged version. But the motive was even more twisted than simple ideology about fairness. It turned out that Patricia's sister was looking to move to Coeur d'Alene and wanted to buy a home in Lakeside Estates. But Patricia's sister wanted waterfront access without paying waterfront prices. The plan was to claim all the docks as community property, which would make the waterfront homes less desirable and drive down their values. Then, Patricia's sister could swoop in and buy one at a discount. It was a conspiracy to commit fraud and to depress property values for personal gain. The prosecutor's office decided to file charges against all three board members, Patricia Whitmore, Gerald Simmons, and Linda Chen. They were each charged with forgery, fraud, conspiracy, and attempted theft. The fourth board member, Thomas Morrison, claimed he had not known about the scheme. He said he had been away on a business trip during the crucial board meeting where the plan was approved. The investigation seemed to support his claim, as there were no emails or messages linking him to the conspiracy. He immediately resigned from the board and issued a public apology. The trial was scheduled for September. In the meantime, the HOA was in chaos. The three board members had been forced to resign. Emergency elections were held, and a new board was installed. The new president was Donald Reeves, the longtime resident who had supported me from the beginning. One of his first acts was to formally apologize to me on behalf of the association and to rescind all fines and violations that had been issued. My civil lawsuit against the HOA continued in parallel with the criminal case. Rachel argued that the HOA should be held liable for the actions of its board members and that I was entitled to damages for the stress, legal fees, and invasion of my property rights. The new board, under Donald's leadership, made a surprising decision. Rather than drag out expensive litigation, they agreed to settle. The HOA would pay all of my legal fees, issue a formal written apology, and pay me $50,000 in damages. In exchange, I would agree not to pursue any further claims against the association itself, though I could still pursue claims against Patricia, Gerald, and Linda personally. I accepted the settlement. I had never been interested in destroying the HOA or bankrupting the association. I just wanted my property rights protected and to ensure that this kind of abuse could never happen again. The new board also passed a resolution establishing a homeowner bill of rights, which included protections against arbitrary fines, requirements for transparency in board decisions, and a clear process for challenging board actions. It was a complete reversal from the authoritarian regime that Patricia had been running. In September, the criminal trial began. I was called as a witness and testified about the day Patricia and her cronies had invaded my dock and presented me with the forged covenant. Other neighbors testified about the intimidation tactics the board had used. The forensic document examiner explained how the covenant had been altered. The defense attorneys tried to argue that it had all been a misunderstanding, that Patricia had genuinely believed the covenant allowed for community docks. But the emails were damning. There were messages where Patricia explicitly discussed editing the covenant to say what we needed to say, and making sure we have documentation to back up our claim. The jury deliberated for less than 4 hours. Patricia Whitmore was found guilty on all counts. Gerald Simmons was found guilty on all counts. Linda Chen was found guilty on conspiracy and fraud, but the jury acquitted her on the forgery charge, apparently believing that she had not been involved in the actual alteration of the document. At sentencing, Judge Campbell did not hold back. You three held positions of trust within your community. Homeowners relied on you to act in good faith and to follow the law. Instead, you engaged in a calculated scheme to defraud a member of your own community and to steal his property. This kind of abuse of power strikes at the heart of property rights and the rule of law. Patricia Whitmore was sentenced to 18 months in prison and ordered to pay restitution. Gerald Simmons received 15 months. Linda Chen received 12 months with 6 months suspended, meaning she would serve 6 months behind bars and the rest on probation. The sentences shocked many people. HOA disputes rarely resulted in criminal charges, let alone prison time. But the judge wanted to send a message that forgery and fraud were serious crimes, regardless of whether they occurred in a corporate setting, a government setting, or an HOA setting. In the civil case, I also obtained judgments against Patricia, Gerald, and Linda personally. Each of them was ordered to pay additional damages. Between the criminal restitution and the civil judgments, Patricia Whitmore was financially ruined. Her house went into foreclosure. Her husband, who claimed he had known nothing about her schemes, filed for divorce. By the time everything was resolved, it was nearly a year after that day when I had seen them standing on my dock with their tape measure and their sign. My dock was still mine. The sign was long gone. And I had something else too, peace of mind. On a warm Saturday afternoon in August, I was sitting on that same dock with a fishing rod in one hand and a beer in the other. The lake was calm, the sun was shining, and I could hear boats in the distance. Donald Reeves walked down from his house and waved at me. "Catching anything?" he called out. "Not yet," I replied, "but that's not really the point." Donald laughed and continued his walk along the shore. The neighborhood had returned to normal. The new HOA board was reasonable and transparent. People actually attended the monthly meetings now because they knew their voices would be heard. A few neighbors had approached me and apologized for not speaking up sooner. They said they had noticed Patricia's increasingly authoritarian behavior but had been afraid to challenge her. They had been worried about fines and retaliation. I told them I understood, but I also encouraged them to never let fear stop them from standing up for what was right. My story had spread far beyond Coeur d'Alene. I had been contacted by journalists, podcasters, and even a producer who wanted to make a documentary about HOA abuse. I did a few interviews because I thought it was important for people to understand how easily this kind of corruption could take root in a seemingly mundane institution like a homeowners association. But mostly I just wanted to move on with my life. I had fought the fight, won the war, and now I wanted to enjoy my property in peace. One afternoon, I received a letter in the mail from the Idaho State Bar. It informed me that Brad Sullivan, the attorney who had represented the HOA, had been suspended from practicing law for 6 months due to his failure to properly verify the authenticity of the covenant document before presenting it to the court. While the investigation had concluded that he probably did not know the document was forged, he had violated his ethical duty to ensure that documents filed with the court were accurate. I felt a small measure of satisfaction reading that. Brad had been willing to defend Patricia's actions without doing his homework. He had been more interested in winning the case than in ensuring justice was done. The suspension was deserved. As fall arrived and the leaves began to change colors, I reflected on everything that had happened. It had been an exhausting, stressful, infuriating experience, but it had also taught me valuable lessons about the importance of standing up for yourself, about not backing down when you know you were right, and about the critical role that documentation plays in legal disputes. If I had not gone to the county recorder's office and obtained that certified copy of the covenant, Patricia might have gotten away with it. If I had not kept detailed records of every interaction, every letter, every fine notice, Rachel would not have had the evidence she needed to build such a strong case. If I had been intimidated by the HOA's threats and simply given up, I would have lost my dock, and Patricia would have been emboldened to target other homeowners. The experience had also restored some of my faith in the legal system. Yes, it had been slow. Yes, it had been expensive. But ultimately, justice had prevailed. The courts had protected my property rights. The criminal justice system had held the bad actors accountable. The system had worked. I heard through the grapevine that Patricia Whitmore had been released from prison after serving 13 months of her sentence for good behavior. She had moved out of state, reportedly to Arizona, where she was living with relatives. I hoped she had learned her lesson, though I suspected that someone with her personality would always struggle with the concept that rules applied to her too. Gerald Simmons had also been released and was working as a cashier at a hardware store, a far cry from his previous career as a financial consultant. Linda Chen had served her 6 months and was now on probation, working at a call center. Their lives had been derailed by their decision to participate in Patricia's scheme. I did not take any pleasure in their downfall, but I also did not feel any sympathy. They had made choices, and choices had consequences. The new HOA board under Donald's leadership had proven to be excellent stewards of the community. They had focused on the basics, maintaining common areas, organizing neighborhood events, and enforcing reasonable rules about things like lawn maintenance and noise levels. They had not tried to expand their power or invent new restrictions. They understood that their role was to serve the community, not to rule over it. Property values in Lakeside Estates had actually increased in the year since the scandal. Apparently, having a reasonable HOA was a selling point. Real estate agents were advertising homes in the neighborhood as being in the community that stood up to HOA corruption and where property rights are respected. My own property value had gone up significantly, both because of the general neighborhood trend and because my dock was now famous. The dock that sparked a revolution, as one article had called it, had become a local landmark of sorts. I had even been invited to speak at a state legislative hearing about HOA reform. Idaho was considering new laws that would increase transparency requirements for HOAs, create stronger penalties for board members who abuse their authority, and establish an ombudsman office to handle homeowner complaints. I testified about my experience and urged the legislators to pass the reforms. The bill was still working its way through the legislature, but it had strong bipartisan support. In December, almost a year and a half after the nightmare began, I received one final piece of news. The Idaho Court of Appeals had upheld the criminal convictions of Patricia, Gerald, and Linda. They had all appealed their sentences, arguing various legal theories about why they should not have been convicted or should have received lighter sentences. The appeals court rejected every argument and affirmed the trial court's decisions. It was truly over. No more appeals, no more legal uncertainty, no more waiting for the next shoe to drop. I owned my dock, free and clear, with no cloud on the title and no threat from the HOA. That Christmas, I threw a party on my dock. I invited all of my neighbors, Rachel Norton and her family, Detective Hayes, Donald Reeves and the new board members, and even Margaret Fletcher from the assisted living facility. We strung up lights, set up heaters to ward off the December chill, and celebrated not just the holiday but also the victory of common sense over corruption. As I stood there, surrounded by friends and neighbors, looking out at the dark water of Lake Coeur d'Alene, I felt a deep sense of gratitude. Gratitude for the people who had supported me, for the legal system that had protected my rights, and for my own stubborn refusal to give up when things looked bleak. Someone asked me if I would ever consider serving on the HOA board myself. I laughed and said absolutely not. I had no desire to be part of HOA governance. I just wanted to be left alone to enjoy my property. But I also promised that I would always be vigilant, that I would always speak up if I saw the board heading down the wrong path, and that I would never take my property rights for granted. As the party wound down and people began to head home, Rachel Norton pulled me aside. "You know, Adam, this case is going to be taught in law schools. It's a perfect example of how important it is to verify your sources, to do your due diligence, and to never assume that someone in authority is telling you the truth. I hope it also teaches people not to be intimidated by their HOAs," I said. "For too long, homeowners have been afraid to stand up because they think the HOA has all the power. But the law is on the side of property owners, as long as you are willing to fight for it." Rachel nodded. "That's exactly right, and you fought like hell." After everyone left, I stood alone on my dock for a few minutes, just breathing in the cold night air and listening to the gentle lap of water against the pilings. This dock, this simple wooden structure extending into a lake, had become a symbol of something much larger. It represented the idea that individuals have rights that cannot be trampled by bureaucrats and petty tyrants. It represented the principle that property ownership means something, that it is not just a privilege granted by an HOA, but a fundamental right protected by law. I thought about all the people across America who were probably dealing with their own HOA nightmares at that very moment. People being fined for having the wrong color mailbox, or for parking their car in their own driveway, or for planting the wrong kind of flowers. I hoped that my story would give them courage to fight back, to stand up for their rights, and to not let fear or intimidation force them into submission. The legal battles had cost me a lot of time, stress, and money. Even with the settlement from the HOA, I had still been out of pocket for various expenses. But it had been worth every penny. Some things are worth fighting for, and property rights are at the top of that list. As I finally headed back inside for the night, I took one last look at my dock. It was just a dock, nothing special in the grand scheme of things. But it was mine. I had paid for it, I maintained it, and no one was ever going to take it away from me again. The saga of the Lakeside Estates, HOA, and the Forged Covenant had come to an end. Patricia Whitmore and her co-conspirators had been held accountable. The community had been reformed, and I had learned that sometimes the only way to protect what is yours is to stand your ground and fight, even when the odds seem stacked against you. In the months that followed, life settled into a comfortable routine. I went to work each day at my job as a software engineer, came home to my lakefront property, and spent my evenings and weekends enjoying the dock that I had fought so hard to keep. I bought a small fishing boat and began exploring more of Lake Coeur d'Alene. I invited friends over for barbecues and boat rides. I lived my life. The HOA continued to function smoothly under Donald's leadership. There were no more manufactured crises, no more power grabs, no more attempts to invent new rules or restrictions. The monthly meetings were well attended, but brief, focused on practical matters like landscaping contracts and snow removal. It was boring in the best possible way. I ran into Thomas Morrison, the former vice president who had not been involved in the forgery scheme, at the grocery store one day. He approached me hesitantly, clearly unsure of how I would react. "Adam, I just wanted to tell you again how sorry I am about what happened," he said. "I had no idea what Patricia was planning. If I had known, I would have stopped her." I believed him. The investigation had been thorough, and there was no evidence linking him to the conspiracy. "I know, Thomas. You weren't part of it. No hard feelings." He looked relieved. "I'm selling my house. My wife and I decided we need a fresh start somewhere else. Too many bad memories here." I understood that. Even though Thomas had not been guilty of anything, his name had been associated with the scandal. Some people in the neighborhood would always wonder if he had known more than he claimed. It was probably easier to just move away and start over. "I hope your fresh start goes well," I told him sincerely. He thanked me and walked away. I felt a little bit of sympathy for him. He had been on a board with people he thought he knew, and they had turned out to be criminals. It was a hard lesson about how you can never really know what is in someone's heart. By the spring, another development had occurred. Several other HOAs in Idaho had reached out to me, asking me to speak at their meetings about what had happened and how to prevent similar situations. I agreed to a few of these speaking engagements, not because I enjoyed being in the spotlight, but because I genuinely believed that education was the key to preventing HOA abuse. At one meeting in Boise, I addressed about 100 homeowners who were dealing with their own problematic board. I told them my story and then gave them practical advice. Document everything, know your rights, read your governing documents carefully, attend board meetings, and do not be afraid to push back against unreasonable demands. The HOA only has the power you give it, I told them. If you stand united as homeowners and demand accountability, the board has to listen. They work for you, not the other way around. After the meeting, several people came up to me and shared their own horror stories. One woman had been fined $2,000 for having a vegetable garden in her backyard. Another man had been told he could not fly an American flag on his own property. A couple had been hit with constant violations for minor issues like a small crack in their driveway or a fence that was supposedly an inch too tall. I listened to all of these stories and gave what advice I could. In some cases, I referred them to Rachel Norton or other attorneys who specialized in HOA law. In other cases, I simply encouraged them to stand firm and not let the board bully them into compliance. The more I learned about HOA problems across the country, the more I realized how lucky I had been. Yes, I had faced forgery and fraud, which was extreme, but I had also had the resources to fight back. I had been able to afford a good attorney. I had the time and energy to pursue the case. Many people facing HOA abuse did not have those advantages. They were stuck paying unjust fines or living under oppressive rules because they simply could not afford to fight. It made me angry. HOAs were supposed to protect property values and maintain communities. Instead, in too many cases, they had become petty fiefdoms run by people who enjoyed exercising power over their neighbors. Something needed to change at a systemic level. That is why I continued to support the HOA reform legislation that was making its way through the Idaho legislature. The bill ultimately passed in April and was signed into law by the governor in May. It included provisions requiring HOAs to provide detailed financial reports to homeowners, limiting the circumstances under which fines could be imposed, and creating a state-level ombudsman to investigate complaints. I was invited to the signing ceremony at the state capitol in Boise. It was surreal to stand there with legislators and other homeowner advocates as the governor put pen to paper and turned the bill into law. The governor even mentioned my case specifically in his remarks, calling it an example of why reform was needed. "No homeowner should have to go through what Adam Brennan went through," the governor said. "This law will help ensure that HOAs operate with transparency and accountability, and that homeowners have recourse when their rights are violated." It felt good to know that something positive had come out of my nightmare experience. The new law would not solve every problem, but it was a step in the right direction. As summer returned and I found myself sitting on my dock once again, beer in hand and fishing rod at my side, I thought about how much had changed in 2 years. I'd gone from being a regular guy minding his own business to being a minor celebrity in the world of HOA reform. I had testified in court, spoken at legislative hearings, and been interviewed by media outlets across the country. But at the end of the day, I was still just a guy who wanted to enjoy his dock in peace. And now, finally, I could do exactly that. No more legal battles, no more HOA drama, no more forged documents or fraudulent board members, just me, my dock, and the beautiful waters of Lake Coeur d'Alene. I caught a trout that afternoon, a nice-sized rainbow that put up a good fight. As I reeled it in and admired it before releasing it back into the water, I felt a profound sense of contentment. This was what I had been fighting for. Not just the dock itself, but the right to live my life on my own terms, on my own property, without interference from petty bureaucrats. The sun began to set, painting the sky in shades of orange and pink. I sat there watching the colors change, feeling the gentle rock of the dock beneath me and listening to the sounds of the lake. Somewhere in Arizona, Patricia Whitmore was living with the consequences of her actions. Somewhere in Coeur d'Alene, Gerald Simmons was working his minimum wage job. Somewhere else, Linda Chen was on probation. But I was here, on my dock, exactly where I belonged. Justice had been served, property rights had been protected, and the rule of law had prevailed over corruption and fraud. It had been a long, difficult journey, but I would do it all again in a heartbeat. Because some things are worth fighting for, and this dock, my dock, was one of them. As darkness fell and the stars began to appear overhead, I gathered my fishing gear and headed back to the house. Tomorrow would be another day, and I would wake up as the rightful owner of my property, my dock, and my slice of the American dream. And that was something that no HOA, no matter how corrupt or determined, could ever take away from me.